of the man that the plaintiff in this case, Leslie Price, had a short-term affair with. And there is a question as to how many times they actually slept together. So that is something that the defense is going to be able to get in. And I'd like to introduce our guest commentator today. His name is Robert Altchiler. He is a defense attorney practicing in New York. He was formerly a district attorney, assistant district attorney in Kings County, Brooklyn, New York, and he teaches trial advocacy at Pace Law School. Welcome, Robert.
Hi.
You know, it used to be when you had rape cases, everything about the victim used to come in. And rape victims, it made them very, very reluctant to testify because they didn't want to come out and have their whole history, you know, dirty linen, dirty laundry, in front of the jury and for everyone to hear. And we've come back from that position. And there are certain protections for rape victims. Here we have a woman who's suing in civil court, and it seems like a lot of what she has done sexually is coming into evidence against her. And why should that matter? Why should it matter as to whether or not she was forced on this one occasion to have sex?
Well, I think that the judge is doing a very good job. He's being very fair and even-handed. You're right. It used to be that a rape victim or a sex assault victim would be brutally and ruthlessly attacked in every civil or criminal case. The pendulum has swung back substantially, even to the point where now, as a criminal defense attorney, I say that they've taken too much cross-examination away from a criminal defendant.
As a criminal defense attorney.
As a criminal defense attorney.
As a prosecutor, you might not feel that way.
As a prosecutor, I could probably argue the other side of it. But I think what the judge is trying to do is, on a piece-by-piece basis, he's trying to determine how is this helping the jury, how is this hurting the jury? Is this diverting the jury's attention from the thrust of the case? And it's a very difficult task, but he is being very even-handed about it.
Well, in the case of the defendant, George Shin, he let in one incident which supposedly, if you go along with what the plaintiffs say, mirrored the incident at hand, which it did. Supposedly this woman said she was taken to his mansion and she was forced to have oral sex with him. In this case, though, in the case of Leslie Price, we're talking about, they want to talk about whether she walked around nude in her house, whether she had oral sex with her husband, whether she had sex with a friend while she was separated from her husband. What does that have to do with the incident at hand? You know what? You're going to get to think about that because the judge is on the bench and we're going to go right into the courtroom.
We have some live witnesses. We'd like to go ahead and call them if you will permit us.
And then as soon as we take the first break, I've got the, what's this fellow's name? Jeffrey Price. I got his deposition designations. I will tell you, and I'm not trying to do anything except to prepare you for this. So little of it am I going to allow that you may want to reconsider publishing it in any event, but I'm going to go through it and tell you why and what, and we'll discuss it. Anything else we need to take up before we bring the jury in?
Yes, sir, Your Honor. I know you've ruled on the Angelette, but when we get a chance, I'd like to make a little bit more of a record on the examination as far as the credibility.
I think that'd be a good idea to go ahead and do that right now.
All right, so I've got some cases I'd like to hand forward.
Okay.
The first case I've handed you is a case called North Greenville College versus Sherman Construction Company. In that particular case, the court talked about that the fact, and it's under Head Note 3, that considerable latitude is generally allowed in the cross-examination of an adverse witness. And then the court quoted McCormick in stating that the law recognizes the slanting effect upon human testimony of the emotions or feelings of the witness toward the parties or the self-interest of the witness in the outcome of the case. partiality, or any acts, relationships, or motives reasonably likely to produce it may be proved to impeach credibility. And then the court went under Head Note 5 and made its ruling and reversed the trial court, said it was an abuse of discretion not to allow impeachment. In this particular case, it was impeachment of prior litigation between the witness and the party against whom the witness was testifying. The next case we provided the court is a case called State v. Marlowe, which is a case that has a fairly lengthy discussion of issues involving impeaching the credibility of a witness. In this particular case, where whiskey was furnished to the witness involving the testimony, and then the court, well, that was actually a short case. And then the other case we've handed the court is Moore versus Atlantic Coastline Rail Company, South Carolina Supreme Court decision, which talks about admissibility of evidence of subordination of a witness by a party to a suit is admissible as evidence tending to show falsity or fraudulent nature of the claim, which would be another basis, I think, on which this could be allowed. In the court, in that case, on page, it's like 475 of the opinion, which would be page 6 of the opinion I've handed you at the top, said that subordination of a witness by a party to a suit or his attempt to do so is admissible as evidence tending to establish the falsity or fraudulent nature of his claim upon the theory that it tends to show such parties' consciousness of the weakness or injustice of his cause is well settled. And so I would draw the court's attention to those cases and just point out, Your Honor, that under the best light of Mr. Angelette's testimony, he was a debtor at the time he gave his deposition, to not only to Mr. Deal, but to Mr. Jarrett, who was identified as the agent of Mr. Deal, and of course both of them are agents of Mr. Shin. If you look at it in its purely clinical sense, since there was no note due setting the terms of payment, the payment could have been demanded at any time, and I believe any loan or gift from an agent of an adverse party to a witness who is critical in the case should be admissible to show bias under, I believe it's Rule 608.
Yeah.
Thank you.
Thanks. And, I've really considered this carefully, Mr. Dominic, and I appreciate what you're saying. And maybe if Mr. Angelette were here, and maybe if something else got said, there might be a little bit different story. I'm not going to hear any more argument on this. And so if Mr. Parrish points out something to you that he thinks is just absolutely like a home run, a four-bagger, I'm not going to hear it because I really thought about this. There is no, ma'am, oh, jeez. Oh, my God. We got a juror who says, I had a reporter ask me about this case. Now, that's something serious, and that's something I'm going to have to deal with. And it's none of our other reporters, none of our other jurors who we dealt with, but I'll get with him in a second. I don't think that there's any suggestion that this testimony at this deposition was directly procured by any kind of buying or plying with liquor or anything like that. I understand what you are saying, that a previous statement given on February 28th or whenever it is, 1998, to Mr. Deal and his minions was in fact, you say, procured by plying Angelette with liquor or beer and giving him $40 or loaning him $40 to use for a room or whatever. But you really, the matters about which you would seek to utilize that statement are, to the extent that they're inconsistent with the deposition, are matters that the ones that are now being testified to are beneficial to you, vis-a-vis what was said in the previous statement, because he now is denying things that were said in the previous statement, for the most part, as I understand it. Unless I let that whole statement in, which is more respectfully garbage in this case that I don't want to trash this case up with. I'm simply not going to allow it because I think that it's not appropriate, quote, impeachment under the circumstances as I see it now. So respectfully, I'm not going to do it. It may be an abuse of discretion, and I'm not going to deal with it any further. Ask Ms. Nobles, how about get Juror 129 in here now, and we'll deal with that. Notice I had a reporter ask me about this case, and it's signed by Juror 129. Did y'all talk? Apparently not. Oh, we can? Good. Yes, sir. Have a seat, Mr. 129, whose name is known to me and the rest of these other folks. The note that we've got from you says that I had a reporter ask me about this case, and what I really would like to know is, please tell us, in your own words, how this came about, who it was, if you know.
I was going out the door to go to lunch, and I had went to lunch and I come back and I was sitting outside on the bench smoking a cigarette. This fellow walked up.
Outside the front?
Yes, sir.
Okay.
He walked
Do
up.
not take a picture of this juror. I'm sorry. Okay, thank you. I'm sorry. Forgive me for screaming. I scream sometimes. Yes, sir.
Anyhow, he walked up and sat beside me, and he said, "Did you know there's a case about George Shin?" And I said, "I'm not allowed to talk about any cases." And he said, "Are you a juror?" I said, "I'm not allowed to talk about it." And he said, "Well," how did he put it now? "I just wanted to know if you knew about the case of George Shin and what you thought about it." I said, "Again, I'm not allowed to talk about it."
What happened after that? Anything?
No, he left.
So in short, let me make sure I understand this, and please don't get the impression I'm putting words in your mouth. If my understanding and my recapitulation right now is different from what you said, you tell me. As I understand it, you're sitting there. This person apparently did not know who you were,
Okay.
came up to you randomly because you were outside the courthouse and asked if you were aware of the case, and you gave him the responses that you've indicated. Is that correct?
Yes, sir.
Did he or she or whoever, was it a male or female?
It was a male.
Did that person either identify himself or, other than as a reporter, or did that person give you or purport to give you any information about this case?
No, sir.
So that person asked only what you thought of this case. Is that correct?
Yes, sir.
Did that approach by that person in any way, or has it caused you to in any way doubt your ability to continue on this case as a fair and impartial juror to both sides?
No, sir, I have not.
Do you believe that you can continue to be a juror on this case and hear it and decide it solely on the evidence presented and the law as I give it to you?
Yes, sir.
Thank you, Mr. 129. I'm going to ask Ms. Nobles to take you out in the hall, and don't seat him in the jury room until I have an opportunity to confer with the counsel there. And, sir, you need not mention this to your other jurors. It's not of any consequence to them. Okay,
Yes,
sir?
sir.
Thank you.
So it seems like this contact is really, let's go back and listen to the judge first.
I guess I got these people so attuned to not saying anything that they jump at anything. Okay, we'll ask him to go back in there and he can continue on the case. All right. I'm sorry, Mr. Dominic, we just discussed your last gasp at the Angelette statement, and then was there anything else we needed to discuss? Mr. Parrish, I don't mean to cut you off. If there was something else Mr. Parrish wanted to point out, go ahead and do it. Another basis. I recognize the ability of a party to challenge the credibility of a witness who's testifying. I just think that this would be misleading and confusing, and don't intend to allow it. Mr. Henson?
Your Honor, before the jury comes in, our next witness is going to be Mrs. Spitz, and there's a videotape to authenticate that. I guess to properly do it, I'd need to show it to her.
Well, has she seen it lately?
She has seen it.
Okay. And is there going to be any question as to his authenticity or the genuineness of it?
No, sir, as long as she can tell us right now, we can dispense with the formalities.
How long is it?
Just short.
A minute and 30 seconds.
Well, why don't we show it to Ms. Spitz now and determine if Ms. Spitz can identify it, but that would entail putting Ms. Spitz on the witness stand.
I mean, I could do this in the presence of the jury. I just didn't want to.
Yeah, I understand. But and if they were going to object, they'd have a proper objection. If they're not going to object, that's why I was trying to find out if they were going to object.
I'm sure it's her video.
Well, show it. You see, you wanted to show it to her in the presence of the jury.
She didn't tell me it was her video, but that's fine. If she's going to say that she took it, you can go ahead and just put her up and let her say she took it, and we're not going to object.
Let's just do that.
Great, let's do that then. Yeah.
John, you need to get
Is there an echo in here? Great, let's just do that.
I'm sorry, Your Honor.
Will you do that?
Ms. Chandler, you didn't, try to step out of your gender role or anything like that, did you?
What role? I'm sorry.
You didn't try to approach him. You didn't don male clothing and approach somebody, did you? No. It's a joke, Miss Chandler. Thank you. It's said lightheartedly, please. Okay, ma'am, you Miss Spitz. You understand what they're going to ask you. They're going to play this videotape for you. It's going to be in front of the jury. Then they're going to ask you, is that the videotape you made on such and such a date? And I'm assuming, we're all assuming you're going to say yes, because if it's not, we got a real serious problem. And if you think you need to view it ahead of time, you might ought to go with these folks right now. But did you only give them one videotape?
Yeah.
Okay, thank you. I think that'll take care of it. Huh? The note, the last note.
First, let's talk about this juror who said that he had a reporter come up to him and ask him about this case, and it's kind of a no harm, no foul situation. The reporter apparently did not know that he was one of the jurors and was trying to get some reaction, but the juror, because the judge has been warning them so much, rightly told the judge what had happened, but obviously this isn't the kind of thing that's going to affect, and he said it wouldn't, his impartiality. Would you have any problem with keeping his juror on the jury?
Not at all. The juror did exactly what he or she, he was supposed to do. Right. The judge has done his job very well because he has them on their toes, and seemingly innocuous contact can affect the jurors. So no matter what contact takes place, it's important the juror report it to the judge.
Because these jurors obviously know that this is a high-profile case, that there are reporters around, there are going to be reporters wanting to interview them after the case, there's a camera in the courtroom, and there's a lot of attention to it. So they already know that people are going to be interested in talking to them after, so it doesn't come as a surprise. But this can happen. You know, I've covered